Ready? 3, 2, 1, start. This clearly indicates that the allegations against the petitioner were without any basis. Stop. Thus, the petitioner was discharged from the criminal liability and the criminal proceeding against the petitioner was closed. Stop. The appellant contends that apart from that, the departmental inquiry which was initiated against the petitioner on the same set of allegations was also closed by the department wide 21/11/2008 stop. While closing the said departmental inquiry, it has been recorded by the disciplinary authority that the final report had been submitted under FIR number 217 under sections 342, 365, 506 IPC stop. The criminal proceeding against the petitioner was closed by the court of CJM, indicating that the charge against the petitioner was not proved. Stop. Para. Accordingly, the competent authority closed the departmental inquiry by revoking the suspension order and reinstated the petitioner in service. Stop. It has been therefore contended that thus not only the petitioner was cleared of the charges based on the complaint filed by the informant but also released from the detention under NSA as there were insufficient materials and departmental inquiry initiated against the petitioner was also closed. Stop. It has been submitted that all these actions initiated against the petitioner were based on the complaint which had been found to be without any basis. Stop. However, the petitioner, even after being cleared of all the charges as mentioned above, was dismissed from service by invoking the provision of Article 311 within bracket 2, second proviso, clause within bracket C of the Constitution. Stop. He also submits that the detailed procedures have been laid down in the office memorandum dated 18/8/2008 for invoking provision of Article 311 within bracket 2, second proviso, clause within bracket C of the Constitution of India. Stop. He submits that since it is an extreme provision, the authorities have to scrupulously follow the procedures laid down in the said office memorandum. Stop. He submits that as per the aforesaid office memorandum, after necessary materials are collected against an employee, the head of the department has to furnish the relevant materials to the administrative department, which after necessary examination is to forward it to the department of personnel, who in turn has to forward it to the committee of advisors. Stop. He submits that the committee of advisors consists of high officials. Stop. The committee of advisors, which has to decide whether the employee concerned has to be informed of the charges against him and be given an opportunity to furnish his explanation or deny any such hearing in the interest of the security of the state. Stop. If the committee of advisors forms the opinion that if it is not advisable to inform the person concerned of the materials and charges against him before proceeding further, they have to record such an opinion and put up the matter to the Honorable Home Minister, who in turn would place it before the Chief Minister for his approval. Stop. Contentions of the state government learned counsel strongly opposed the contentions raised by the petitioners. Stop. He has also produced the relevant records and submitted that perusal of these records would clearly indicate that there was sufficient materials before the competent authority to arrive at the subjective satisfaction. Stop. Over.